district pro bono debt collection calendar training. Thanks for coming. We have a great panel today, a lot of great presenters. I'm seeing a lot of names on here and recognizing several of you. Thank you for being willing to get on and your interest in this debt collection calendar. As many of you know, October is pro bono month. And so that's one of my favorite times. My name is Brooke Robinson, and I work with Timpanogos Legal Center. We are a nonprofit that serves statewide. And so there's lots of ways where you can get involved during this month, where you can get involved with either legal calendars, pro se calendars, taking pro bono cases. So you can always contact the bar's pro bono program. We also have a free legal clinic that we're doing at the Ogden shelter at the YCC. That's on the first and third Thursdays of the month from 4 to 6 p.m. We're still looking for volunteers. I'll put my email in the chat as well. And our other presenters will fill us more in on the details of kind of how this calendar will work. But as of right now, we're looking for volunteers on Thursday mornings, starting at 8:05 at the Farmington Court. For right now, that's done remotely, but Marcus at People's Legal Aid can help answer those questions. We'll put both of our emails in the chat, and he will also send out an email to everyone attending the CLE today to kind of follow up on when that's going to start. We're looking at the second week in November. So you'll get all of that information. Feel free to invite your friends, encourage everyone to get involved with Pro Bono Month. And I'll also put our details about the YCC shelter clinic in the stats as well in the chat. And so as we're getting started, we have several presenters. We'll go to Judge Cornish and then Lacey Charrington, Kyle Myers, and Marcus Deegan with People's Legal Aid. And so we're all going to just take a couple moments and kind of go over the details of what to expect from a pro se debt collection calendar, talking about the law, different things to go over, how it fits in. But just know that there is a big need right now for representing these defendants on debt collection calendars. Many of you probably read that report from the Utah Foundation and the Utah Bar Foundation called The Justice Gap. And in that, they found some stats saying that for the 62,000 debt collection cases in Utah, nearly 100% of the petitioners have lawyers compared with only 2% of the respondents. So as you can tell, there is a big need, and we're grateful for all of you for joining this calendar or even just joining our CLE. I'll put a link into that report as well. It's very informative, and it shows that there is such a big access to justice gap, and we appreciate anything that we can do to try and help represent the defendants that are really struggling and just trying to figure out how to navigate this legal system that is so foreign to so many people. So thank you for being here today, and I'm going to turn it over to Judge Cornish.
Great. I want to begin by thanking everybody for being here as well. I know a lot of times pro bono legal service is one of the last things that we're trying to cram into a very, very busy day. And I recall viscerally when I was practicing that being incredibly intimidated by some of these kinds of pro bono opportunities. I wish I knew then what I know now. Let me start by talking about generally what the debt collection or the collections calendar looks like. We have it every Thursday morning beginning at 8:05. Usually, though there have been occasions where it goes longer, it usually lasts between 8:05 and about 10 a.m. So it's about a 2-hour time period. It is set up as a cattle call. And so there are usually a number of matters that are set on that calendar. It's both evictions, occupancy hearings, so unlawful detainer cases, and then usually collections cases. Here in Davis County, we tend to define collections cases as those sort of contract-based cases that have in dispute less than $20,000, which are all assigned over to me for that calendar. So smaller contract cases, though, to a lot of these defendants, the dollars involved are not small to them. It's just in the scheme of things and what the courts do, the dollars involved are smaller in that sense. What we primarily see on the kinds of cases we primarily see on the debt collection calendar, Probably first and foremost are occupancy hearings, so unlawful detainer cases where landlords are seeking, and frankly, every now and then a defendant is seeking an occupancy hearing for immediate occupancy of a rental property where there has been some kind of underlying breach of lease, whether that's payment, other kind of breach of lease, or a termination where there's been a holdover. The landlord's seeking immediate occupancy of those, and they come up incredibly fast. They're on a very short timeline, particularly for defendants. We see usually between 2 and 4, I'd say 2 and 4 of those kinds of hearings every Thursday. There are usually a number of just simple pretrial conferences on collections cases. So usually an underlying contract claim for oftentimes for credit cards, medical bills, things that have gone to collections that are in that under $20,000 prayed for damages. And the plaintiff's counsel has requested a pretrial conference, frankly, I think in many ways to get the case on track, to get the discovery that they need. But I think actually our plaintiff's bar very, very often asks for those pretrial conferences for an opportunity to speak with the defendant and see if they can't work out a stipulation or an agreement in those cases. The other thing that we see a lot of are enforcements of collections. So we see enforcements of writs of continuing garnishment or writs of garnishment where debtors have come forward after judgment has been entered. They're faced with a writ of garnishment of some kind, or a writ of replevin, that sort of thing. And they have an objection and they're upset that their judgment is being collected in a certain way. And so they filed a reply and request for hearing, and they have the creditor, the judgment creditor there, and they're objecting to the way that it is getting collected. So I'd say that there are maybe 3 or 4 of those a Thursday morning pretrial conferences, somewhere between 1 and 8 any given Thursday morning. And then, like I said, occupancy hearings somewhere in the neighborhood of 1 to 4 any given morning. Those are the typical kinds of cases and the typical kinds of ways in which these hearings present themselves on our collections calendar. When we know that we have volunteer attorneys present, we oftentimes take a little break at the beginning to try to link up volunteer attorneys with defendants. So it's not uncommon for volunteer attorneys to be meeting their client for purposes of today's hearing at the very beginning of that hearing and giving them an opportunity to reach out by phone to talk to the client. And then a lot of times those volunteer attorneys have an opportunity to speak with then plaintiff's counsel. And so I frankly try to accommodate linking up or making that first connection between volunteer attorneys and unrepresented defendants, giving them a moment, and then oftentimes pushing those hearings off down the calendar, calling them and then recalling them so that volunteer attorneys have an opportunity to speak with those unrepresented folks before having the matter called. What Brooke said is absolutely true. What we tend to see on that collections calendar is that more than 95% of plaintiffs are represented, and they oftentimes are represented by very skilled counsel that have specialized in the kinds of cases that they have on that collections calendar. We have some incredibly talented plaintiffs attorneys that do landlord-tenant work, and they are there every week, and they know what they're doing, and it is something that they are very familiar with. And on the other side of that, we almost always have a defendant that is unrepresented, that is coming in and oftentimes is simply confused about the process. If they've managed to find their way to an occupancy hearing or they've managed to find their way to a pretrial conference, there's an awful lot of confusion on their part, not just over the substance of their claims, whether they actually have defenses, but also the procedure of their claims. A lot of times, like I said, the kinds of hearings that we're seeing on the collections calendar are specialized kinds of hearings. that really we're looking at a very narrow legal issue. For occupancy, it's not the whole story of what happened. We're really looking at some very narrow facts in those kinds of cases. On a reply and request for hearing, on an objection to a garnishment, we're looking at some very specific things. And so we have defendants that are coming, they want to tell their story to somebody, and they want to know if they have any defenses, and what can they do as a practical matter to move their case forward, or frankly, to resolve it. And so we have an incredible need for volunteer attorneys to help unrepresented defendants. And this is and because of the specialized way that these hearings present themselves, they are a perfect opportunity for a limited representation, frankly. Absolutely perfect opportunity for a limited representation. A lot of times, like I said, what these defendants, unrepresented defendants, are looking for is somebody to tell their story to ask if they have any defenses, to orient them. And frankly, what I see the true value of volunteer attorneys is that win or lose on the merits of their claim, they provide a bridge to negotiate with plaintiff's bar. And I think, frankly, plaintiff's bar appreciates that as well, that opportunity to speak with a volunteer attorney that knows what the actual issues are in this kind of hearing, and to perhaps reach a resolution. They act as quite a bit of a buffer in negotiating a resolution, not only that plaintiff's bar can work with, but frankly, that defendants can work with. And that a lot of times the remedies that come out of the collections calendar, the evictions and collections calendar, the kind of remedies that I mete out under the law are very harsh sometimes for the defendants, and sometimes they just need a hair bit more wiggle room. And if they're represented, even just for purposes of that hearing, they a lot of times can, one, come out oriented on whether they have a defense, and two, negotiate a solution that is better for them than the one they're going to get from the court. So it ends up being an incredible win for them, even to just have that opportunity to have somebody else negotiate on their behalf. So that's the huge need that we have. And I think that the really true value is having better outcomes for a lot of these unrepresented defendants in the sense of negotiating with plaintiff's bar. Almost always they get a better, almost always, not always, but almost always they get a better resolution negotiating through a volunteer attorney than they do just throwing themselves on the mercy of the court. That all being said, there is something in it too, I think, for particularly young attorneys, or attorneys who, if you're in a civil practice and you don't see a lot of civil trial work, I will tell you, occupancy hearings, they go to evidentiary hearing not uncommonly on the collections calendar. And so there is an opportunity to develop those skills, cross-examining witnesses, making an argument on the fly, but even some of those witness and evidentiary skills can come up, and you can get a chance to dust them off, particularly as we're coming out of COVID and everybody's trial skills are a little rusty. This is my last plug, and that is that I don't mean this to be a harsh plug, but everybody should recall that we essentially have rules, Rule 6.1 of the Rules of Professional Conduct, that encourages every single lawyer to provide 50 hours of legal services without fee or expectation of fee. And this kind of a calendar is a perfect opportunity to do that in sort of 2-hour increments. You're not taking on a case for forever. You're not taking on a client for forever. It's not something that's going to hang around. It's something you can hop in on a Thursday morning, get done, feel good about it, and not have a pro bono case that's following you for a long period of time. I was, when I was in private practice, I would often take on a pro bono case and realize very quickly that just because it's a pro bono case, it's just as much work as any one of my other paying cases. This is one of those ways to sort of limit your exposure to outside obligations. Let's call it that way. It is a quick, easy way. And I think that the return on investment is huge, particularly for a lot of these folks that you get to feel really smart too. I will tell you that. You get to feel incredibly smart. The questions that these folks have are truly questions you can answer. And it is an incredible service to them, like I said, even just to have their legal questions answered by somebody that they trust and to be able to orient them on what is going on in their case. So that's my plug. A description of how our collections calendar works. A reminder that you have an obligation to do pro bono service, but evidently all of you probably know that since you are here and are looking for ways to do that, and I can't applaud that enough. And then I can't tell you how thankful the court is when folks reach a negotiated resolution that at the end of the day, sitting over here, I think is probably better for both of the parties than anything that I could mete out. And so that's my plug for volunteering for the collections calendar. I'll turn the time over. I'm not sure who I'm supposed to be turning over to. I think Ms. Charrington, who's representing our plaintiff's bar, and I think she's probably going to echo that it's really nice to have a lawyer to negotiate with on the other side. But Ms. Charrington?
And in fact, Lacey, I'm so sorry. This is Marcus from People's Legal Aid. Can I interject really quickly to just ask the good judge a quick question?
Yes, please.
Thank you so much. Judge Cornish, I understand that we only have you for part of and not all of this CLE. Otherwise, I would have saved this question for the end. But I wanted to ask something that I imagine is probably front of mind for a lot of people who are contemplating this volunteer participation, which is, and it's a question that's running across all the state courts right now, is remote appearances. Can you tell us a little about where your courtroom is at currently for remote appearances on this calendar and where the court sees it going from here?
Currently, this calendar is still being run remotely. And it will be at least through the end of the year. I think it will continue to be through the end of the year. I wish I could give everybody more direction on that. The Davis County judges, at least, are in discussions about when and how we go back to in-person. At the end of the day, I recognize that a lot of these kinds of cases, one, I think it's advantageous to the lawyers, not just volunteer attorneys, to appear remotely by WebEx. It makes it easy to do it even from just dropping in from your desk at work rather than having to stop into the courthouse. It's easier for my plaintiff's counsel, for my plaintiff's bar, who are spread all over and may have other obligations that they need to meet as well in other courthouses. But frankly, at the end of the day, for a lot of these defendants, taking time off work and coming down to the courthouse is incredibly disruptive to their lives. Let's be honest, they wouldn't be in a collections matter if they had a lot of funds and a lot of time to take off work, a lot of freedom to take that time off work. So I think from an access to justice standpoint, keeping it by WebEx or a good majority of it by WebEx is what we're looking to do here in Davis County. That being said, the one issue that we are weighing is that when it comes to evidentiary hearings, sometimes that can be challenging to do by WebEx, though. At the end of the day, I think probably the disadvantages to trying to do an evidentiary hearing by WebEx are outweighed by the access to justice that a lot of these people have. And when I say these people, I mean everybody involved having in the convenience of being able to do it by WebEx. So we're evaluating that. The calendar will continue to be by WebEx, I think, at least through the end of the year.
Very good. Thank you, Your Honor. And Lacey, I am so sorry for interrupting. We can shave that interruption off my time at the end.
No problem. Like Judge Cornish said and Marcus said, my name's Lacey Charrington and I'm representing the debt collection bar today. We represent many different creditor clients. Most of them consist of a high volume and generally low balance collection accounts. Most of what I represent is medical and a sprinkle of some other debt collection cases. And I don't do any landlord tenant collections, so I can't speak on behalf of that section of the debt collection bar. I've been doing collections for almost 25 years, and I'm a second generation debt collector. So it's in my blood. Throughout what I'll talk about today, you'll hear me refer to the defendants as customers. Our industry is trying to soften the communication with they were once referred to as debtors, and we refer to them as customers. So when you hear me say customer, that's who I'm referring to are the defendants in these cases. So generally, these cases arise due to customers not understanding insurance, and I'll talk mostly about medical because that's what you'll mostly see. Not all, but it will still all apply. these turn into simple breach of contract claims, and most of them are deductible balances or small copays owing, just the part that goes to the patient's responsibility. And there's quite a disconnect, unfortunately, in customers understanding their insurance benefits. And like Judge Cornish referred to, it's nice to just have somebody, another attorney besides us, listening to them to understand what their frustration is on why this balance is still owing. So keep in mind, before it gets to a litigation point, there are multiple times that the creditor tried to contact the customer. There's notices, phone calls, even texts and emails now. In the medical world, there's the EOBs from the insurance companies, and they aren't generally sent to collections until sometimes 4, 10, 12 months after the date of service. So many points of contacts, and I always get a giggle out of customers that say, I didn't know anything about this until someone came to my door and served me a summons. And the multiple points of contact before that are plentiful. And unfortunately, due to the volume of these accounts that are sent to collections, there comes a point when litigation is necessary to get the attention of the customer. In my own firm, less than 2% of my entire portfolio of clients, less than 2% of the accounts that we begin to work on actually go to litigation. So for me, it's a really small amount of my practice, and generally most of the debt collection agencies in the state see that same type of number, and only a 2% portion of their portfolio actually goes to litigation. And that's where we as the attorneys from the debt collection bar step in, and I'll discuss generally how the plaintiff's bar approaches these cases once we get to litigation. Now, I'm not going to touch a lot on the 10-day summons, because usually once we get to a hearing, we're well past that, but there's a lot of attorneys that don't understand what a 10-day summons is. This is a tool for us to serve a defendant prior to filing the case with the court. This gives the customer a really great opportunity to contact us and try to settle the debt before it gets filed with the court. And the benefits of the 10-day summons are numerous. If you want more details, you can read up on the 10-day summons and the benefit of that. I believe it's only cases under $20,000 that can use a 10-day summons, but they are very beneficial. But we're past that point once we get to a hearing. Now, the benefit of the pro bono counsel helping on this calendar, and I admit from the very beginning, I was very skeptical at the success that this would have. I was worried that some attorneys would come across on the pro bono side to help these defendants, and it would make these cases more difficult than they have to be. And honestly, it's been exactly the opposite effect that I've seen. I'll give you an example. Just last month in September, I had 6 cases on Judge Parker's calendar in the downtown court in the 3rd district. And of these 6 cases, we were able to settle 5 in a very short amount of time with the help of pro bono counsel. It was it's been very successful. I'm trying to get the 4th district court down here in Provo to understand the benefits and put something together too for those cases. Again, these are very, very simple breach of contract claims. The defenses of insurance should have paid, unfortunately, is not proper. They've had the opportunity well before this point to take care of insurance. So now what? The customer wants to be heard, and once they understand that insurance isn't going to save them, they're much less defensive with the help of pro bono counsel, and they understand that it's a basic contractual obligation. So again, I can't speak on behalf of all of the debt collection bar on how they handle these cases, but many of the attorneys that I've worked with in the past on the debt collection bar, a lot of us do it the same way. We're really easy to work with. We'll come down on our own overhead, which is the attorney fees and generally part of the interest that's accrued, to help get these cases taken care of in a quick, easy manner that helps resolve them quickly. Rarely will we settle on our creditor client's portion of the debt. I mean, there are a time when that might happen, but rarely do we get to that stage in the game with our negotiations. Now, like I said, we're at the pre-judgment stage at this point, and the next part I'm going to say these things lightly. If you're going to help on this calendar, I've seen some of the pro bono attorneys get overzealous in unnecessary ways. And if motions for dismissal and other things starting to get filed right away, we don't have any choice but to run up our attorney fees and have to respond to those motions. I'm not saying there's not a time when that's not proper, but please understand that we're not bulldogs on this side. We've been hired to collect these low balance accounts on behalf of our creditor clients. And these customers will tell you again that they've never heard from our clients. They've never heard from us before, but they have, and they generally know it's owing. They just are like, oh crap, I've got to take care of this now. So we're all, the attorneys that I've worked with on the debt collection bar, we really do try to work with pro bono counsel. We try to work with defendants. We're willing to come down our fees for lump sum payments and also work out long-term payment plans. And then we file those stipulations with the court, so the court knows what we're looking at going forward. So that's what we're trying to do, is just get the patient's customer, defendant, however you want to refer to them, to understand what the contractual obligation is. Now, Judge Cornish did refer to some garnishment objection hearings, and most of these come before the court because the person has had a default judgment entered against them and they have a garnishment now issued on them, and now they want to attack the judgment through a garnishment hearing. And it's a pretty simple explanation from pro bono counsel that, this is the wrong place for these types of objections. You can't attack the judgment at this point in the game. There are other remedies for that, and they can go into that as they see fit as pro se counsel. But most of the times it's a simple objection, and there's not an objection, and those get taken care of there. And with the help of pro bono counsel, it really helps us take care of those. And in my opinion, I think with the help of the pro bono counsel, it not only speeds things up, it keeps the court calendar clean of unnecessary trials that don't need to go that route. And in the long run, it does cost the customer a lot less because they aren't running up unnecessary attorney fees on filing things that my insurance this, my insurance that. Let's just get another ear on this and help get these cases taken care of. So I appreciate all the help of all the pro bono attorneys that jump in and help on these cases. It really has been amazing. And I was extremely skeptical from the beginning, and I've really enjoyed getting to know a lot of attorneys and work together to get these taken care of. So if you've got any questions for me, I can answer those now, or we can wait till the end.
Sounds like no takers for the moment. Lacey, thank you so much for sharing your insight and perspective here. And I'm sure, at least I'm hopeful, we'll get a few more questions after Kyle and I do our piece. Kyle, if last call for any questions directly for Lacey at the moment. Otherwise, I'll be passing the baton over to Kyle to talk generally about the defense side of appearing on these calendars.
Okay, so I'm Kyle Myers. I ended up stumbling into this area of practice as a volunteer for a lot of the reasons that Judge Cornish gave, where I was a brand new attorney. There wasn't a whole lot of opportunity to get into court for me. And so that was I heard about the calendar, and so that became my opportunity to go into court. And so I just echo what Ms. Charrington and Judge Cornish mentioned, the benefit of these calendars. And then just talking about, so I was asked to talk a little bit about just general principles of debt collection. And I think Marcus is going to talk a little bit more specifically about the landlord-tenant side. There are a few things that are very specific to that. And so as a general rule, with these, as was mentioned earlier, these are typically contract cases. And so the typical contract defenses would apply, such as statute of fraud, statute of limitations. I believe in the state of Utah for written contracts, the statute of limitations is 6 years, and for written contracts, and then 4 years for oral contracts. And then, as Ms. Charrington mentioned, I think that the goal, or at least she alluded to, I think the goal of most plaintiffs' attorneys are just to get paid. I think that having a judgment for $10,000 is nice, but if it's uncollectible, I don't think that's going to help anyone. And I don't think anyone's terribly interested in that. And so that's ultimately the goal for a plaintiff. The plaintiffs will, just as a general rule, I found that plaintiffs' attorneys and plaintiffs in general will reduce any amounts that they're claiming if you can put a bit more money up front. And then payment plans frequently are an option. You can do monthly installments. I've done balloon payments. There are a few options. Utah code does, I'm just going down my list apparently of all my talking points. So Utah specific rules. Let's see, your biggest tool that you have in negotiating these cases is that your client can't pay. If your client is working part-time at a McDonald's for minimum wage, that's probably one of those incentives that you can use. I would also note that even if the plaintiff were able to get a judgment, there are limits on garnishment. If, again, going back to that person who's working part-time at McDonald's, I believe, and I'm open to correction here, I believe that if they're working under a certain number of hours that they can't. Oh, go ahead.
Kyle, it's well, and I'll prevail upon our excellent colleague, Ms. Charrington, to confirm this, but my understanding is that the way that the state statute is written is in parity with the federal statute, and that the way the math works out is that it's approximately, if you make less than about $900 a month, you are probably uncollectible as far as your wages go. Is that $900 a month mark approximately right?
Yes, that's about right. We, in my office, we don't garnish if they make less than $250 a week. So we're right in that same area. We just won't issue it because it's not going to stick.
Very good.
Okay, so that's worth noting with your clients whenever you meet with them. Find out how many, typically when I meet with clients, I'll ask how much they're making, how many hours they're making, where they're working, those sorts of questions for that exact reason. Also, you can't garnish from individuals who are receiving Social Security. So that's another limitation that you can kind of use to help move the negotiations along and move the case forward. Again, plaintiffs typically like to get paid money. And if there's no way they can ever collect the money, even if they get that $10,000 judgment, you're more likely to be able to figure out a solution of some sorts. Or there's the situation where your client legitimately doesn't have any income. They're unemployed for whatever reason. Typically, that's something where you're going to run into, at least my experience is usually what we'll do is we'll just set it out for further pre-trial. Or we'll just say, hey, let's come back in a few months. So those are kind of some basic ideas. So typically when I'll meet with a client for this calendar, I'll explain whatever type of hearing it is. If it's an immediate occupancy hearing, I'll explain what's going on in an immediate occupancy hearing. If it's a pretrial, I'll explain that it's a pretrial. And the goal of that is to hopefully narrow the conversation a little bit. If you have 15 to 20 minutes to meet with this person, you really don't want to hear the entire life story they have going on. And then typically I'll look into what they know about the debt, what they understand. Ms. Charrington did mention that sometimes these people will come in and they'll say, I've never heard of this debt. sometimes they just don't understand what's going on. And that's the biggest source of frustration. And then figure out where the disputes are on what the amount is owed. Sometimes they agree they owe an amount, but they do disagree on the amount that's owed. For example, you can have a landlord who decided to charge the tenant for replacing an air conditioning unit that was mostly functioning when the tenant left, or they're being charged for treble damages and they don't understand why treble damages are being charged in their eviction case. And so those are those opportunities to talk with the defendant, the customer, however you want to refer them to them as, and try and discuss the law with them and try and help them understand what to do. It also helps to look over the contract, if there is a written contract that they have. When these calendars were in person, they would typically have a copy of it. If not, I've never had anyone from the plaintiff's bar not willing to provide it very quickly to me, as well as any invoices for any things that they were charged for. And that'll give you a chance to go over those and discuss those with whoever this defendant is. And then once you kind of have that information, you can hopefully talk with the other attorney. If there is a good defense, most of the time, plaintiff's counsel will own up to it if it's an obvious one. If not, they're usually pretty professional. They'll be willing to negotiate with you. And if you can't come up with a resolution on the case, it's an opportunity to argue something and work on those skills. Typically, if we can't resolve the case, I'll give the client some sort of next steps on what they need to do. If this is an objection to garnishment, typically you do need to let the client know, hey, this is an objection to garnishment hearing. There's an underlying judgment. That's really what you need to attack. Here's how you file a motion to set aside. I'll typically also text them the link to the Utah State Court website, self-help center, where they have instructions on how to do that. If we can't resolve it at a pretrial, I may instruct them a little bit to expect either a motion for summary judgment, or I think Judge Cornish, oh good, she's gone, so I can say nice things about her again. So, or mean things, I don't know. But you can instruct them on a little bit about to make sure they do their disclosures and to be prepared to deal with whatever comes next. And so that's kind of my spiel. Is most of this is negotiating, most of this is just basic contract law. I think there's specifics of landlord-tenant Marcus is going to cover, such as the treble damages issue. And it's usually pretty straightforward, even if this isn't your main area of practice. This is pretty easy to slip into if you've done general civil litigation or are interested in giving it a shot. And worst case scenario, I don't think I've met anyone who's made the problem worse. Lacey may disagree.
Yeah, Lacey, do you want to name some names? Who's made it worse? Let's really let's dive in. Let's get into details here.
No, there won't be any details shared on that.
Thank you so much, Kyle. I appreciate it. I do want to, before I dive into my prepared remarks, really bang a gong about a couple of things that have already been said in this session. First of all, I really want to draw and underscore under something that Judge Cornish said earlier. I have yet to, now I'm a fairly young attorney. I was only, I graduated from law school in 2017. So I am admittedly still, I think I still technically qualify as a baby lawyer, but in my brief years of attorney infancy, I have yet to find an opportunity for giving direct services pro bono help that qualifies for your yearly 50 hours more just efficient than participating in these calendars. As the good Judge Cornish noted, taking on pro bono cases can be very time consuming and can demand every bit of your time that a paying client could, or more, depending on how fraught the situation is. And you wind up thinking, oh God, what have I gotten myself into? Or another commonplace that sometimes folks will do pro bono services in immigration cases, but that is likewise a unique body of law, very complicated and very detailed set of forms that can be very intimidating, overwhelming, take up a lot of your time, and sometimes dissuade people who would otherwise have a great yen for public service to not get engaged in pro bono representation just because of fear of, oh, how much could this sprawl out and take up of my time? These calendars are a great opportunity to get in quick and dirty 2-3 hours of your pro bono, and then you're that much closer to making your 50 for the year. As referenced, these calendars typically run for about 2 hours, 8:05 a.m. to about 10 a.m. Sometimes they run a little longer. Likewise, you are, of course, entitled to and indeed encouraged to try to reach out to any defendant you have been assigned to the day before, or maybe even sooner than that, to try to get discussions going early. But generally speaking, it is exceptionally rare that these cases would wind up taking up even as much as 5 hours total between prep and attending the hearing and doing negotiations, etc. Much more often, it is more like a commitment of 2 to 3 hours. Sometimes less, depending on the nature of the case. This can be a very, very efficient way of getting in that pro bono service. And for that reason alone, I want to strongly encourage everybody to get involved. Another thing I want to echo is indeed what the others have said, that these cases are largely negotiation settings. While I strongly encourage everybody who gets involved in these cases to engage in analysis as if this is a paying client and they really need to scrutinize every I dotted and T crossed to make sure there are not issues with statute of limitations, failure to abide by certain collection practices laws, both state and federal, scrutinizing whether or not, was this a home solicitation sale? Did they get their 3-day rescission rights? If this was an extension of credit, did it apply the Truth in Lending Act correctly? Scrutinize all these details, but ultimately the others in this meeting have identified correctly. These cases are usually fairly straightforward ones where somebody just does not understand or let this claim fall by the wayside for them. And now they're panicking because even though, as mentioned, they are relatively small dollar compared to so much litigation, they are huge dollar for these particular defendants. So therefore, this likewise will go towards the idea that this is not a extensive time commitment to be involved in. Now, that said, as to my specific prepared remarks, and goodness knows everyone assembled here knows how I can talk, so I will try to keep my remarks as efficient as possible. As previously mentioned, the greater bulk of these cases for which coverage is needed in this calendar are what one might call standard debt cases, hard consumer debt matters deriving from, as previously mentioned, credit cards, car repossessions, medical debts, etc. The calendar also consists of occupancy-related matters, that is, the eviction stage of an eviction lawsuit. Now, the hope is that People's Legal Aid will be able to cover the greater bulk of those cases. And anyhow, we need to do an entirely separate training to cover all the legal issues that can show up in an occupancy hearing. So my remarks are not going to be covering that so much. Although if coverage winds up being needed in greater amounts than currently anticipated for occupancy matters, please do keep your eye on your emails for CLE notices about further trainings on that topic. Everybody here knows, of course, I likewise love to interact with my fellow professionals. As a baby lawyer who's worked in nothing but landlord-tenant, I work in a very rarefied little world of the law, and I relish the opportunity to trade notes with fellow professionals and share what limited wisdoms I have accrued as it relates to occupancy issues in eviction cases. So if at any point anybody does wind up needing to get assigned an occupancy-related case for this volunteer calendar, do not hesitate to hit me up directly to ask me questions. I love talking with folks. So what I am here today to talk to you about is specifically residential rental specific debt claims. Now, these are either lawsuits that started as an eviction and are now in the money damages stage of the eviction lawsuit, or it's a lawsuit that originated as a debt collection action that arose out of a residential rental relationship. For instance, claiming that the tenant left the place in bad conditions and their security deposit wouldn't cover it, and claiming that the tenant is now on the hook for further damages in excess of normal wear and tear. Now, PLA will endeavor to cover these cases wherever possible if there's a low tide of occupancy-related hearings in a given week, but the demands of covering occupancy-related hearings will inevitably leave us short-staffed certain weeks, and we will need to prevail upon volunteers to cover these residential rental debt-related cases whenever possible. And the types of hearings that fall within this category are nothing outside of the case types that have already been referenced. Typically, pretrial conferences, aka settings where, generally speaking, no massive decisions are made about the case other than perhaps scheduling a trial date. But commonly as not, they are used mainly just for an opportunity to get the parties together and see if there's any resolution to be had. There are also motions to set aside. Those occasionally come up. More commonly, as previously noted by Lacey, is we see objections to garnishment, where somebody thinks that what they're doing is in substance, or at least in prospective effect, a motion to set aside, but they didn't do it right. They did it as a reply and request for a hearing, trying to challenge the underlying judgment. And you get to have the joyous experience of explaining to them, sorry, what you're trying to effectuate here, you didn't do the right way. And if you try to push for getting your day in court today, you're not going to get it because the judge is going to say, sorry, this has to be moved for in the appropriate fashion, give the other party an opportunity to respond adequately. But nonetheless, they do arise on the regular, and that is part of the job, is to explain, well, here's how you actually go about doing this. Now, in turn, since those types of hearings are usually hearings at which, again, no great decision is made by the court, my role today is primarily to identify some common issues that appear in residential rental cases that can be at least used for negotiations purposes. First thing to look at in a residential rental related case, and this is specific to situations where it started as an eviction lawsuit in some way, is, was there a defect in the eviction notice? For example, was it a non-payment case and there was a pair vacate notice that only gave 3 calendar days rather than 3 business days to pair vacate? Starting as of, I believe it was the beginning of 2021, notices to pair vacate have to explicitly state 3 business days. Doesn't matter if the way the timing worked out with service is that it wound up still being 3 business days, or doesn't matter if the landlord voluntarily gave more than 3 business days within which to pay up. Nonetheless, the notice must expressly state you have 3 business days to pay up. If it only says 3 days, that is a defective notice. Why does that matter? It matters because these are critical for knocking out treble damages, these punitive type damages that are baked into the statute, saying that a landlord can get your daily rent tripled for every day you overstay past the end of an eviction notice. If the notice was not valid, trebles cannot be collected. Now, commonly speaking, trebles are waived in negotiation settings. The plaintiff's bar in the eviction side, typically speaking, does not push for getting trebles as a part of negotiations, but they do make for a big thumb on the scales for sussing out other defenses or affirmative claims the tenant may have. If you can't knock out the treble damages, then even a substantial offset for bad conditions or other bad actions by the landlord are almost certainly going to just get subsumed by those trebles and still leave the tenant with a substantial net liability. Other types of notice issues can be, for example, if it was a notice for claim of nuisance, did the events identified in the eviction notice actually reasonably amount to a nuisance, a private nuisance action, or was it just some small annoyance and a molehill was made into a mountain for a claim of eviction based on nuisance? If the notice was to comply or vacate, can the tenant show that they in fact complied with and or didn't commit any violations subsequent to the notice period ending? If I get a comply or vacate notice on November 1st saying you have to clean up the stuff on your patio or we're going to evict you, well, if I can prove that as of November 3rd, my patio was cleared out and an eviction lawsuit came forward anyway, I may have a defense that that eviction notice was not valid. or rather, at least the claim that I was unlawfully detaining was not valid because I cured within the terms of the comply or vacate notice. Another common issue that can come up is security deposit deductions. And both in eviction cases and in just regular residential rental debt cases, commonly security deposit claims are at issue, that on top of whatever other wrong was committed, you also left the place with damages in excess of normal wear and tear. Well, the thing to scrutinize when you look at the initial disclosures is, are these in fact monetary claims for damages in excess of normal wear and tear? Or are they just routine maintenance? Does the lease say anything about preemptively agreeing to certain expenses like carpet cleaning always being assessed and always at the landlord's choice of vendors after the tenant vacates? Do the invoices or receipts in the landlord's disclosures line up with the date that the landlord generated a move-out report, making a final statement of here's how much we're claiming is owed? Perhaps among the most critical questions to ask in these sorts of settings as you're assessing those claims, did the tenant take move-out pictures? Can the tenant prove to sufficient certainty what the conditions of the apartment were when they left? I have worked a case where a landlord was claiming thousands of dollars in excess damages beyond what was covered by the security deposit. And for once, the tenant actually did take move-out pictures, and this tenant left the place in pretty much immaculate condition, except for 2 carpet stains and a couple holes in the drywall. When you have move-out pictures, your ability to fight back against certain deposit claims gets a lot stronger. A lot of tenants don't take those, and so if they didn't take move-out pictures their last day they were there, they may be in a disadvantageous position to try to defend against the claims. Now, it is still ultimately the plaintiff's burden to prove their damages, and just showing invoices alone may not be enough. But what else can they prove? Did they take their own pictures, etc.? These are all things to be looking for in a security deposit setting. Another common issue. Let's say the landlord is claiming the tenant moved out early and that the landlord is entitled to future rents. Rents going forward beyond the move-out date based on an ongoing lease agreement. Well, how long did the landlord take to re-rent the place? Landlords have an affirmative duty to mitigate their damages in the same way that they have to with security deposit claims. They can't replace a $100 carpet with a $3,000 carpet. Similarly, with an early move-out, landlords have a duty to re-rent the place promptly. Can they show that they did so? How much notice did the tenant give? Maybe the contract said you're supposed to give 60 days notice and the tenant only gave 30, but it's in a place in the heart of downtown where their application's being filed a dozen a day. Can it reasonably be said that it still took the landlord an extra 30 days to re-rent the place after the tenant moved out? That's an open question to be ultimately decided by a judge, but it's one thing to consider as far as when you're looking at one of these cases and negotiating one of them. Lastly, big issue to come up is just what kind of equitable offsets can be claimed here. The Fit Premises Act does put certain limitations on a renter's remedies for bad conditions, but that's not the end of the story. There has been some good case law in Utah saying that notwithstanding the Fit Premises Act, if there were significant bad conditions that the tenant had to live with, then the tenant may be entitled to an equitable offset. This is a particular case called Mira v. Campbell, worth memorizing if you're ever going to take on one of these cases. Let's say the conditions in the place were absolutely awful. There was sewage pooling at the tenant's ankles. Tenant complained and the landlord refused to do anything about it, as is their right under the Fit Premises Act. There's no way to force a landlord to make a repair. But the tenant was still nonetheless stuck waiting around through raw sewage for a week before they finally just up and left as a matter of constructive eviction. Can something be claimed for that? Were there ongoing problems before then? Mold in the walls, things like that, that likewise made living conditions substantially uncomfortable. Was the electricity going out all the time? Did the landlord perhaps willfully shut off the utilities? All of these things can either make for affirmative counterclaims or at the very least, and more often is the case, affirmative defenses to try to offset tenants' liabilities in this situation and perhaps negotiate for them to get a better outcome. As stated by Kyle, ultimately these cases are about money. Money is what solves them. And so if you can persuade a landlord or a landlord's agent, their attorney, that, hey, if this goes to trial, this person is going to be able to really push on these certain offsets, then perhaps a better deal can be brokered. The tenant winds up paying at least less than they would have had they not been represented, and still get a better outcome. And so with that, we're now at the final stage of our CLE, which is Q&A. Does anybody have any? Oh, I see we did get one question in the chat. Will they allow LPPs to volunteer on these calendars? Brooke, I think the answer to this is yes. I've not seen a lot of this myself, but does that sound right to you?
And if Pamela wants to jump in and answer that, I believe to the extent if that's like an area that they are certified in.
And so we do allow LPPs on the 3rd district calendar for debt collection. And the reason we choose to do debt collection is because we can assign pretrial conferences where they're designed to be negotiated, and there's not the opportunity that an argument in court would ever be necessary because there's nothing before the judge. So that's how we use them. And so many of the cases are pretrials that it's a huge help, and there's always a lot of cases available, but that's how we've handled it.
That sounds like a great standard. I'm good for that. Yes.
Here. Anyone else have any questions for myself, Kyle, Lacey, anybody at all?
I hope it's not impertinent, but I have a question. I'm a little bit curious about what do you do with criminal. I've had a couple of cases come up. What happens when somebody has been accused of a criminal act? Have you ever seen that? What kind of affirmative defenses are you familiar with, maybe for keeping someone in their home if they've been accused of a crime?
So this would be specifically an eviction, an occupancy related claim
Yes.
based on an allegation of criminal acts. It ultimately comes down to one of evidence. While it is not a beyond a reasonable doubt standard in those settings, it is very expressly just a preponderance standard. Can the landlord prove by a preponderance of evidence that a criminal act occurred? Well, the question is, what is the evidence they have? In this one advocate's experience, there's at least a non-negligible percentage of those cases where the landlord, perhaps the only evidence they have is a police report and a property manager who can say, yeah, the police said they had to come for this one incident, and yeah, here's the copy of the police report I got. If that police report is not properly stamped and authenticated, it is not a self-authenticating document that can be objected to. Commonly speaking, landlords, their attorneys, in my experience, it is inefficient and highly inconvenient to have to bring in somebody from the police department to live authenticate a police record. And so if perhaps that is the entire body of evidence to be had, then it's all hearsay and otherwise inadmissible documents, and maybe you've got it on there. Otherwise, it's just going to be a battle of testimony for the most part. Who saw and heard what at what times, and who seems more credible. In other types of litigation settings, you would hope to have more opportunity to develop the evidence, find other points of leverage to either undermine the testimony against your clients or support your client's testimony. Oftentimes in occupancy hearings, it is such a crunched process that it is not possible to aggregate that kind of evidence and prepare that way accordingly, but there can still be an evidentiary fight to be had. And that is one of those settings where it is particularly valuable for a tenant to have an advocate at these sorts of hearings. Did that answer the question?
More or less, except that I am a little bit surprised that something like the presence of an arrest could be considered preponderance, right? Rather than, yeah, right. Generally, I think we have to have them innocent until proven guilty, but in this case, it sounds like they're kind of guilty until proven innocent.
I'll spare further comment and then to say, yes, it can feel like that. The presumption of innocence only applies in criminal prosecutions by the state, not civil actions brought by a private landlord. Questions from anyone else? And if anybody needs a quick moment to just formulate a final question, I will just give a final
Hey.
plug. Oh, Brooke, go
I
ahead.
was going to say on the chat, we just had a question, kind of the next step for volunteering on the calendar, and if there would be any more specific training.
Yes. So we do not have any training currently scheduled. However, I believe I do have a recorded CLE or two from previous events where we've given trainings specific to occupancy related matters. I'll see if I can dig those up for interested individuals. Otherwise, like I said, I thrilled to the opportunity to speak with my fellow colleagues, and I'm happy to give a quick and dirty private training if the need arises or as cases demand additional support. And then as far as what volunteering and participation will look like from here, this is some remarks that Brooke started the session with, but I'll reiterate. This calendar was an ongoing, more consolidated volunteer affair as of some months ago, and unfortunately it had to be scaled back due to just volunteer limitations. But we're looking to try to reinitiate the calendar as an ongoing affair in something like the second week of November. Since these are always on Thursday mornings, that will be November 10th. So please mark your calendars, anybody who's eager to participate, to block out some time the morning of November 10th. 8 a.m. to 10 a.m. In front of Judge Cornish. And then from there, I'm going to be the one who's going to be coordinating the calendar, at least for immediate purposes, myself and my organization, People's Legal Aid. So we are going to be getting a list of all of the attendees from this CLE. I'm going to be sending out a solicitation email saying, hey, who's ready to volunteer at the next calendar, whenever that may be. As I said, I think November 10th, but if we can get it up and running sooner, we will. And then we'll send out an email, just ask, hey, how many cases can you take on this date? Let me know, and then I'll start assigning them out.
And we did have one more question before we wrap up, saying, are these all back in person hearings? My understanding is right now they are remote.
Yes, Judge Cornish remarked on this earlier, but for anybody who maybe joined late or was drawn away for a moment during her remarks, Judge Cornish mentioned that right now this is currently all remote, and it is expected to continue to be all remote at least through the end of the year. It sounds as if Judge Cornish has her views about trying to continue it to be all remote, but obviously this is as it is in basically every district, it is something of a district-wide decision on what types of cases continue to be remote versus which ones have to be in person. So we will be sending out more information about that soon. But at the very least, from November through December, it is expected to continue to be all remote. Updates to come on the volunteer email list as they emerge. All right. If there aren't any other questions, Brooke, do we have any other business to mention before we wrap up?
No, just thank you for attending. Enjoy the rest of October and Pro Bono month, and we look forward to hopefully working with all of you as part of the Pro Se calendar and find different ways to volunteer in the coming weeks.
And my absolute biggest and loudest thanks to everyone involved in this, to you, Brooke, Pamela, Judge Cornish, even though she is not here, and especially a big trumpeting loud thank you to Kyle Myers and Lacey Charrington. I know you both as private practitioners have a lot of other things you could be doing right now other than this, and I really, really thank you for participating.
Thanks for having us.
Thank you.
Thanks, everyone.